Welcome everybody to the hearing. I'll commence hearing 25, which is General Industrial Zone. Understand that all our participants are Zooming today, so that's fine. My name's Gary Ray. I'm chairing this particular hearing. With me, Commissioner Solomon at the end of the table, Commissioner Reid, Commissioner Willis, and myself. We've also got Jessica, who's the reporting officer, who is on the Zoom call as well. Now, today we have two submitters zooming in. We've got Woolworths New Zealand Limited first, and then we've got the group, some people who are known as Carter Group, and I think actually we have Littleton Pork Company as well. So we've got three presentations. Just to record, we also have tabled statements from Orion, evidence from Melanie Foote, Department of Corrections, evidence from Morris Dale, and Bunnings have tabled a letter basically in support of the officer's recommendations. So the panel will come to those tabled letters and evidence after we've had the presentations from other submitters. All right, we'll start the hearing with Mr. Leakey, who I see has joined us from Woolworths. So we're in your hands, Mr. Leakey. Thank you.
Thank you, Commissioner and panel. Hopefully you can all hear me.
Yes, we can hear you fine. Yep.
And with me virtually is Ms. Panther Knight, who I see is also on the screen. I've tabled pre-circulated legal submissions, which hopefully the panel has in front of them. And I don't propose to go through those line by line, and that the argument for Woolworths has been an evolving one from the earlier strategic directions and urban growth hearing. And for this hearing, I just propose to focus on the general industrial zone component of that broader legal argument from Woolworths, which is essentially the need for the plan to better provide for supermarkets in the Selwyn district. So there's been a similar response in the 42A for this general industrial chapter, which is in my submission an overly strict reliance on the town centre zone and large format retail zone for the provision of supermarkets. So the relief sought by Woolworths that Ms. Panther Knight will expand on seeks to broaden that to the general industrial zone where appropriate. So on page 3 of my legal submissions, there's really 3 limbs to the Woolworths relief for the general industrial zone. There's a policy limb, and this relates to P4. Ms. Panther Knight has supported some amendments to that policy, which have also been, as I understand it, supported by the 42A report writer, which is the addition of a functional need component to essentially carve out that avoid policy in P4. So that's there's alignment between Woolworths and the 42A report writer in respect of that. The point of difference is that the addition of large format retail has been added to that policy through the 42A report. And in my submission, that's not necessary, and that the policy is attempting to protect centres, so the town centre and the local centres, and that it's not appropriate to then add a zone to that, and that the large format retail is not a centre, it's a zone. So Ms. Panther Knight's Annexure 1 deletes that addition of the large format retail zone to P4. But other than that, there's alignment in relation to that policy. It's essentially a policy. The amendments are to essentially keep that consenting pathway open and carving out what otherwise is a strict avoid policy. The second limb is in relation to activity status for supermarkets. Currently in the general industrial zone, supermarkets will be a non-complying activity, and Ms. Panther Knight's evidence supports discretionary activity for supermarkets in the zone, and notably that it's not restricted discretionary as was sought in the CMUS zone. And Ms. Panther Knight will expand on that as to the appropriateness of a discretionary activity in the general industrial zone, and how that enables a case-by-case consenting with appropriate teeth, if you like, for council at the time of consenting. And I'll just add to my legal submissions on this point that in terms of a general discretionary activity, the policy framework becomes critically important because at the time of consenting, decision makers are going to be looking to that policy framework and applying that discretionary activity. So page 4 of my legal submissions, I've just expanded on that somewhat. And then the third limb, and it's a similar position as we were submitting on for Woolworths at the CMAS hearing, and this relates to the appropriate activity status for a general rule infringement. So in this case, outdoor storage and street interfaces. So Woolworths seek a restricted discretionary activity. There's some alignment with the 42A report writer on most of those aspects, but there's 2 further rules that Woolworths seek be restricted discretionary triggers in the case of non-compliance. And again, Ms. Panthonite's Annex Shaw expands on that and also provides some suggested or supported matters of discretion. So to tie off my legal submissions, I've referenced briefly the Commerce Commission market study, which has recently been released, but this is the first hearing I've had the opportunity to speak to it in the Selwyn process. And essentially the market study has made some recommendations quite relevant to the panel's decision making today regarding the enablement of supermarkets in New Zealand to better improve the price, quality and range of groceries. So at 27, I've summarised the outcomes there, or the recommendations there, sorry. Most relevantly, ensuring sufficient land is available for supermarkets, avoiding district plans taking an overly prescriptive approach, and ideally providing excess capacity to enable competition. The Commerce Commission study has no direct bearing in my submission on your decision making in an RMA statutory sense, but it is fully aligned with what Woolworths submit the NPS and the regional policy statement require for the district plan. So in that sense, it's reinforcing the arguments being made by Woolworths to better enable supermarkets in Selwyn. I'm conscious I've moved through my submissions relatively quickly, but as I say, they're not new, so I'm happy to take any questions before I pass to Ms. Panthonite.
Also see if we have any questions. Raven, do you have any questions?
No questions from me, thanks.
Nicole?
No questions from me. I'll submit it.
Okay. Yeah.
Just one question. Thank you for your legal submission. I'm just interested in the Commerce Commission market study component in your statement. And you've identified, or helpfully identified for us, some of the conclusions in relation to planning rules and district plans and the constraints that these provide. And I'm just interested in having not seen the rest of the Commerce Commission's advice, and I'm imagining you have read that in some detail. Yeah. How significant are the planning constraints in relation to these supermarket issues that the Commerce Commission has investigated? How significant are the planning constraints relative to other issues of simply other issues or systemic issues that are not planning related? Is it significant, or is it just a nice to have as opposed to a must have?
Yes, I understand the question, and the way the report is structured is it outlines the situation, and it provides around 4 to 5 recommendations at the end, and one of those is squarely a planning RMA recommendation. So in that sense, and it's the first recommendation in the list. So it's I would argue it's the most relevant of the Commerce Commission study. There are other recommendations not related to planning controls, including private covenants and that kind of thing. But they're pointy recommendations, and there's not a lot of them. So the planning one is critical. What it does do is it relies on the NBA or whatever act we're going to end up with that's replacing the RMA, and I suspect that's where the teeth of the Commerce Commission study will come in, but obviously we're not within that framework yet. So we're in this period of plan formulation, but not within the framework that the Commerce Commission study is looking to address these concerns. which is why I say that the NPS does that for us anyway.
All right, thank you. No further questions.
All right, thank you, Mr. Leckie. I just had a couple of questions. Just on that Commerce Commission market study, I thought I heard you say that it has no bearing on our decision making here, but it's you make the point that the relief you're seeking is consistent with that. Is that the case legally? We're not to put any weight on it as such.
My wording was probably slightly loose there. Sorry. So it is a relevant matter. For example, in a consenting sense under 104, it certainly would be an other matter. So it is something you should have bearing on. I should have really said you're not bound by it, or you don't have to give effect to it, and that it's not an RMA document in the hierarchy of documents. But it is something that is very relevant, and also just puts another perspective on that same argument that Woolworths have been making.
I thank you for that. Another question I had was a sort of more general submission you made that Woolworths have supported, or rather you're making the point that the strategic directions level of the plan supports a centre-based approach. And you've referenced, I think, one of the objectives there, which doesn't come to mind, but
Yeah.
and so what, as I understand your submission through some of the hearings, you're seeking to implement that through the various chapters and make sure that the council delivers on that strategic direction. Is that the thrust of what your legal submission is here?
Yes, that's right, sir. So the notably at the strategic directions hearing, Woolworths didn't seek any amendments to those strategic directions, and that Woolworths are comfortable with them and agree with them. But where we're seeking amendments is through the zone by zone rule framework to enable the achievement of those strategic directions. So you've captured that correctly. The submission from Woolworths is the strategic directions are great. We just need to make sure the zone provisions can achieve them, and therefore achieve those higher order documents.
That's right, and so I understood that right. And in terms of the only policy you're seeking an amendment to here is GIZ P4, and you've asked for the functional need to locate within the zone to be included, and that's been supported by the officer. I understand that because you've given up quite a lot of evidence about the needs of supermarkets to locate on large sites, and they have a lot of truck movements, and some of it's industrial by nature and so forth. I'm just trying to think, will it always be the case that a supermarket operator will always be able to argue a functional need to locate in an industrial zone in every instance? Like it's a basic submission that's made universally, isn't it? So I'm just wondering that would seem to be a fairly easy box to tick, would it not?
I'd agree for a supermarket. It's likely that the functional needs limb is likely to be satisfied just due to the nature of industrial zones, and that they often edge effects can be appropriately dealt with, and car parking can be provided. I think that where the functional needs test will provide a hurdle potentially is for other retail, but for supermarkets, then yes, I'd agree that functional need is likely to be satisfied. And there's a large number of examples of other countdowns around the country that have neatly fit within that industrial framework.
Okay. Thanks for that. And just finally, the words large format retail zones, you've made the point that the addition of those words is not necessary, because a large format retail zone is not a centre, it's a zone. I see that Carter Group, who are the next submitter to present to us, have asked for that in their submission, and we'll need to test that with them. But is your aversion to those words merely because they are not necessary in the sense that it's not a zone? It's not necessary to include those words, or do you have another reason why you would not like to see them included?
No, it's purely it's a more of a philosophical concern, is that what is the intent of the policy? It's to protect centres rather than direct activities into different zones. So if there's Woolworths don't have a particular issue or interest really in what the Carter Group's submission on this is. It's more of a what is the most appropriate planning response, given that the policy is intended to protect viability and function of centres. It doesn't seem a natural fit to add one particular zone to that. So that's the concern, and Ms. Panther Knight will no doubt expand on that from her planning perspective.
Thank you very much for answering those questions, Mr. Leckie. Right, Ms. Panther Knight, we're in your hands now. Thank you.
Thank you, sir. Can you hear me okay, sir?
Yes, we can. Yes.
Thank you. So I haven't prepared a hearing summary statement today, but what I will do is attempt to match Mr. Leckie's efficiency and take you through brief, important paragraphs in my evidence. So specifically, firstly, with reference to paragraph 7, I'm just outlining there that the relief sought by Woolworths in respect of the provisions of the general industrial zone, which I support, is intended to establish a more flexible and targeted consenting regime for supermarkets in the district, specifically to service anticipated residential growth. Turning then to the executive summary of my report, and as neatly explained by Mr. Leckie in terms of those various limbs of the relief. The first is with respect to, in respect of my summary, paragraph 12, seeking a discretionary activity status for supermarkets in the general industrial zone as opposed to non-complying as proposed by council. I consider that discretionary activity status enables a fulsome assessment of effects, and council still has discretion to notify, grant or decline such an application. I consider that the discretionary activity status better enables a case-by-case assessment of supermarket proposals within the zone, acknowledging the significant demand for such activity in the district and the dearth of suitably zoned land. One of the considerations I expect you'll be looking for a little more discussion on is exactly what is the difference between discretionary and non-complying activity status. Obviously, beyond the statutory hurdles of a Section 104D assessment, there are also those slightly intangible aspects in terms of perception that comes along with a non-complying activity status as opposed to discretionary. And there was also a reference at paragraph 38 of my evidence, which came from the proposed district plan decisions version for Waikato District Council, which acknowledged that discretionary activity status was appropriate in the general industrial zone in that district, recognising that such activities may be appropriate and should be assessed on their merits, rather than being actively discouraged through a non-complying activity status. And it's my view that that's appropriate here, and it's one of the reasons I support that discretionary activity status. Back to paragraph 13 of my executive summary, again, I consider any such proposal will allow an assessment of economic effects, including on centre vitality, viability and function, as well as in respect of industrial land supply and demand. In this way, discretionary activity status for supermarkets in the general industrial zone is consistent with the overarching Centres Plus policy framework that you spoke with Mr. Leckie about this morning. And if I can then take you to paragraph 21 of my evidence just on that matter. I'm not aware of any economic evidence to suggest that industrial land supply is so scarce relative to demand that non-industrial activities cannot be countenanced. Indeed, the objectives and policies in the general industrial zone chapter recognise the potential for non-industrial activities to be considered where they are of a similar scale and nature to, and where they avoid incompatibility with industrial activities. In my view, supermarkets by their nature are large in format and utilitarian, nor are supermarkets sensitive to effects arising from industrial activities, such that reverse sensitivity effects, in my view, do not arise. As a result, I consider supermarkets can be accommodated without adversely affecting the efficiency of surrounding industrial land uses. Conversely, I understand the evidence presented by Mr. Foy to the CMUZ hearing recognised the significant shortfall in available and suitably zoned land for supermarket developments. And so for that reason, paragraph 24, I explain my opinion is the discretionary activity status for supermarkets in this zone can achieve an efficient and effective balance between preserving industrial land for its primary use and enabling consideration of the appropriateness of a supermarket proposal out of centre on a case-by-case basis. You'd also heard from Mr. Leckie this morning, and Mr. Chair, you asked the question around the Centres Plus strategy, if you like, with respect to Woolworths submissions. And I consider the discretionary activity status in the general industrial zone adds to that approach and is evidenced by the limited amendments to both strategic directions, urban growth, and so on, down to the general industrial zone objectives and policies, where the only consideration for an amendment we've presented is in respect of policy P4. Policy P4, as you've just heard, is intended to protect centres, and in my view, it's appropriate. The amendment with respect to functional need, I take your view, Mr. Chair, in respect of that being a relatively easy test, for lack of a better phrase, for a supermarket to accommodate. But for that reason, it's appropriate because the intent of the policy is to avoid such retail activity that would not otherwise have a functional need and ought therefore to be accommodated within the centre or a centre. Those amendments, with the exception of the large format retail zone inclusion, I understand have been accepted by the council in the Section 42A report. And I do agree with Mr. Leahy's comments this morning that the large format retail zone is not a centre. It does not need to be protected relative to the hierarchy in the Centres Plus strategy of the PDP, and therefore does not need to be included in that policy. It's essentially setting up a hierarchy, elevating large format retail above general industrial, which in my view is not necessary. However, I do understand the council's concern in the Section 42A with respect to the discretionary activity status arises from a suggestion that supermarkets would not be able to easily fit with other relevant policies in the zone, being policies P2 and P3, which I've addressed in my primary evidence, and I think it's probably appropriate just to touch on those briefly. So with respect to policy P2, paragraph 30 sets that out. And it states, provide for other activities to establish and operate within the general industrial zone where they are, 1, of a similar scale and nature to industrial activities, or 2, ancillary to the main industrial activity on site, or 3, necessary to support the needs of workers within the zone. I've set out in my evidence how I think supermarkets could comfortably align with that policy, such that the discretionary activity status remains appropriate. Critically, I think it's clear that supermarkets are of a similar scale and nature to industrial activities, and the remainder of that policy in my reading are disjunctive, such that you don't need to achieve all 3 tests. Policy P3 at paragraph 35 of my evidence notes, avoid activities that are incompatible with the character and function of the industrial area. As I stated at 36, again, for the reasons stated, a supermarket would not fall foul of this policy by virtue of its scale, form and function. So back to my executive summary, paragraph 15, I support, so that is, I guess, the concluding comments in my view with respect to the discretionary activity status. Paragraph 15 references the appropriate activity status in my view for rule requirement infringements. And I have suggested, like with the CMUZ hearing, that restricted discretionary activity status is appropriate for consideration of infringements to rule requirements. Council had accepted that, except for with respect to outdoor storage or street interfaces, and I've set out in my evidence why I think restricted discretionary activity status still achieves an appropriate assessment framework, and I've proposed some wording to that effect. I do recall Council accepting at the CMUZ hearing that outdoor storage could comfortably be considered as a restricted discretionary activity in respect of rule requirement infringement. It may be that we can further consider that component of formless relief here. Finally, at paragraph 16, in my opinion, the amendments proposed to the general industrial chapter achieve appropriate and sustainable management of natural and physical resources. The amendments also recognise the compelling and competing interests of district growth while ensuring that adverse effects of development are appropriately mitigated. Happy to take questions, sir.
Thank you very much. To see if we have questions, Ray.
No, Ms. Panther Knight's evidence was quite clear. Thank you.
Thanks for that. Just where you talked about Waikato district plan and in their industrial area allowing for supermarkets, are there any other plans, district plans, who do that in New Zealand, or is this the only one? That's why you've referenced it.
No, there are certainly other districts that provide for supermarkets in industrial zones and in a varying number of ways. So Hamilton, for example, allows for supermarkets in their industrial zone as a restricted discretionary activity, subject to a rule standard that requires a centres assessment. And if that centres assessment determines that there is an adverse effect that's unacceptable or significant, similar in respect of a centre, the activity status defaults to non-compliant. In Ashburton, there is provision for supermarkets within the industrial zone, or a similar zone, it's called Business D, I believe, that allows for supermarkets that also have an overlay within the industrial zone, again as a restricted discretionary activity that has been applied via a plan change recently with respect to existing and proposed supermarket sites in that industrial zone. And in New Plymouth, supermarkets are permitted in the industrial zone. There are, of course, examples where supermarkets are discretionary or non-complying. Auckland Council has a non-complying activity status for supermarkets in its light industrial zone, but I would note that that is also with respect to a wider Centres Plus framework that more freely enables supermarkets across the other variety of business zones in that plan.
Thank you. You've given quite a extensive answer to my question, but that certainly answers it. Thank you.
Thank you. So just on that, Ms. Panthenite, so you've used the Waikato example. It's a sort of middle of the range approach from what you've said. There's other districts that do permit it and so on. Have you used that example because of the quote that you've included, which possibly illustrates the point you're making, to enable supermarkets to be assessed on their merits under a discretionary status rather than being actively discouraged? Is that the key point you're making? That's why you've used that example?
That's certainly one of the reasons. It is a key point, but it's also a very recent decision. So the PDP for Waikato was only released in January this year, the decisions version, and I thought that was also appropriate.
And you're not aware of any appeals that have been lodged with respect to that one?
There have certainly been appeals lodged, but no appeals to supermarket provisions.
No appeals to that, okay.
Yeah, and I could just jump in there just to confirm that as well. We're involved in those appeals, and as Ms. Panthenite mentions, none that we're aware of for those retail provisions.
Thank you. I have some more questions, but I'll just hand over to Commissioner Willis in case he has some questions.
Thank you, Mr. Chairman. Thank you for your evidence, Ms. Panthenite. Have you read the evidence of Mr. Phillips, out of interest?
Is that with respect to the Carter Group's assessment?
Yes.
Yes, I have.
So I'm just interested in your views on his recommendations to amend Policy 4. Whether you have any views on his assessment around, I think it's the functional need to locate or that result in or undermine the viability and function, as opposed to it being an and. And I think you may have covered that previously, but did you have a view on his interpretation of that policy and the need to change the and to or?
I'm comfortable with the recommendation to change it. It took me some time to decide whether the and or the or in fact result in very similar perverse outcomes. In fact, spent a bit of time with the whiteboard this morning just trying to make sure I was very clear on exactly what those perverse outcomes might be. I do agree that in fact either way, and or, there is a concern that you're trying just to get through, say, one limb of the policy. With or, I think there is a comfort that you need to be able to demonstrate compliance or consistency with both of the limbs. And so for that reason, I would be happy to accept or on the basis of Mr. Phillips' evidence. And I don't think that changes my view with respect to the way in which supermarkets could align with that policy.
Sure, thank you for that. Because I like you, I did read it a few times just to try and work out, because it wasn't my initial interpretation of that policy. The way that Mr. Phillips was interpreting it. Do you have any comments on the other changes that Mr. Phillips was proposing, which is to include the word significant or change the word unacceptable to significant?
Again, no, I don't have a firm view either way. I would be comfortable with significant. I appreciate that significant and unacceptable can be used interchangeably. Or you could consider significant essentially elevates the test higher, and in my opinion, either is appropriate in this circumstance.
Thank you. And I think I've got one more question. So just in paragraph 38, and you helpfully already answered the question which I would have had around other district plan examples around discretionary versus non-complying status. But just a question on this particular example you've given here. I note that there's a section in brackets, confirm discretionary status of supermarkets in its general industrial zone alongside other retail activity not otherwise provided for. So the decision that you quoted is not limited to supermarkets. Is that correct? It actually covers a range of retail activities. Is that correct?
That's correct. It covers the retail not otherwise provided for. So there are specific retail activities set out that have separate activity status, and those are restricted, or rather they are non-complying in the industrial zone. And that's where they are smaller format retail that would be more appropriate in either of the two business zones in the Waikato district plan.
Right, because thank you. Because I was wondering how it might have treated trade yard-based activity or trade-based retailing in the industrial zone, and whether that was part of that other retail activity in brackets.
My understanding, and I would like to double check this, but my understanding is yard-based would be permitted in the industrial zone. I would need to double check the status of activity for trade supply or trade retail.
Okay, thank you. No further questions. Thank you.
Thank you for that, Commissioner Willis. I was going to ask a similar question on the on Jeremy Phillips' evidence relating to the and/or, because I agree it can be read either way. So thank you for that. I was just looking through the chapter and just trying to see a rule that makes supermarkets a non-complying activity. Which rule triggers or trips it into non-complying? Is it retail other activities, or do you report the rules?
I will double check.
Yeah, this is it GIZ R8?
I'm taking a look at R8, sir. Just one second.
Yeah, okay. Oh, yeah. Retail activity not otherwise listed.
I believe I'll just double check, but I think there is actually a supermarket rule. I'll just double check.
All right. Jess, do you happen to have that at hand? Jess, do you know which rule it is? It might save us a bit of time. That's all.
My computer's going a wee bit wonky. It's the retail activity rule R8, because supermarket is a subset of retail activity, and it wouldn't be able to meet either of those A or Bs, most likely. Thanks.
Okay, thanks. No, that's not really. I just needed clarification on that. What I was interested in, Ms. Panther-Knight, was it doesn't appear that Woolworths has sought any change to the policies that have the avoid word in them, like P4, I think P3. They have avoid, and they don't say unless. They don't say avoid something unless, but they do have some qualifiers. And I'm just thinking I think you make a strong case, for discretionary status on the merits and the particularities of supermarkets. But is there not a problem with the policy framework, which does use the word avoid, which does set up a non-complying status generally? Any comment on that?
Thank you, sir. So my assessment of, say, P3, while it does use the word avoid, is that it's talking about avoiding activities that are incompatible with the character and function of the industrial area. And I'm confident that a supermarket is neither, such that it would be able to pass through that policy or be consistent with that policy. Policy 2 is enabling, and policy P4 we've discussed in respect of those qualifiers, which again, I think a supermarket can comfortably achieve. I'm not a big fan of avoid policies unless it is very clearly setting up the non-complying activity status, as you say, but in this circumstance, the provisions addressed are still comfortable. I consider supermarkets are still comfortable with respect to that framework.
Thank you for that. No, that's thanks for that comment or answer. I'm just going to look at your relief, the actual track changes. Sorry, I'm just getting it up now. I had a question on that. Where is it? Here we go. Yep. So I'm just looking at the it's an appendix, or yeah, it's at the end of your evidence anyway. There's some red tracking and words. There's a new suggesting a new rule, GIZ-R8A, and that's the new rule that you're proposing that would set up the rule specifically for supermarkets, basically. And you've used the word, and this is discretionary, you've used the word any supermarket activity. I haven't been back to check whether there's a definition of that, and I'm wondering whether supermarket activity is sufficiently clear to cover what you know to be supermarkets. And I know there's a variety of other sort of scales and sizes and specialties and everything else. Is there a definition? And if not, do you think it's required?
Sorry, sir. Yes, sorry, I'll let you finish.
Finish, yeah. Yeah, well, sorry, just to explain if there isn't, is a definition required to be associated with a new rule such as this if you're going to use the word supermarket activity?
Thank you, sir. So there is a definition of supermarket in the PDP, and it is a retail activity that uses land and/or buildings for displaying or offering a comprehensive range of food, beverage, and other disposable goods, such as fresh meat and produce, chilled, frozen, packaged, canned, and bottled foodstuffs and beverages, and housekeeping and other personal items for sale to the public. One matter that occurs to me is that that doesn't set up consideration of a larger format supermarket and could therefore fall to include smaller scale activities that are food and beverage oriented, such as dairy or similar. Now, I don't necessarily have an issue with dairies being discretionary in the industrial zone either, and they would fall to be considered favourably under one of the limbs of policy P2 in my view, in terms of being necessary to support the needs of workers within the zone, and a discretionary activity status would be appropriate. On that basis, I'm comfortable that a supermarket activity, or in fact we could just use the word supermarket since it's defined as such in the PDP, with respect to my new rule R8A, and that would allow it to be appropriately interpreted.
Okay, I understand. Thank you for that. And the only other question I had was you've also recommended including some additional matters of discretion, and that's because I think you're seeking that outdoor storage and street interfaces be restricted discretionary matters. And my question is, the words that you've included, are they based on the words that have been suggested by the officer for the other assessment matters? I haven't studied each of those things, but where did they come from, those words?
Thank you, sir. So it's a combination, essentially, of considering other matters of discretion in different plans, consideration of the way in which Selwyn District Council has set up its assessment criteria for various rule requirements, and they're also consistent with the relief sought by Woolworths for the CNUZ zone. So they're a hybrid, if you like, in respect of those considerations.
Okay, thank you for that. I'll just signal to the reporting officer we would like some response or comment on the wording that's been suggested there as part of your reply, as well as the more substantive matter of discretionary status, and to respond to the points that have been made about the Waikato plan, for instance, and that'll clearly be a matter we'd like some response on. Look, I thank you very much for your evidence. I've got no further questions. I'd just like to echo Commissioner Solomon's point. It's your evidence has been well set out and is easy to understand. So thank you very much.
Thank you, sir. Appreciate it.
Take that into consideration. Thank you. All right. Now that Mr. Leahy, is that end your presentation?
Yes, thank you, Chair. That concludes our presentation for today.
Thank you very much. Okay, well, excuse you, and we'll go to the next. We'll go to the next submitter, or we're going to take. Oh no, we're going to take a short break. Actually, we'll take a short break for 10 or 15 minutes. Thank you very much. You're there, Mr. Phillips, and you have a colleague, Lucy. Welcome to the hearing, and thank you very much for coming on a bit earlier. We're a little bit ahead of schedule. This will give us more time to do our site visits. So thank you for coming on. Ms. Forrester, in your hands as to how you wish to present. We've got your statements and evidence, and we'll have a number of questions. But if you want to present something to us, that's fine.
Yeah. So no legal submissions as the panel will be aware, but I am here to answer any questions as they may arise, but otherwise I'll just pass it straight on to Mr. Phillips for the Carter Group evidence.
That's fine. Okay, Mr. Phillips, thank you.
Good morning. I'll take you through my summary, commencing at page 10 of my statement of evidence that's been pre-circulated. So starting at paragraph 10, attachment 1 to my evidence lists the amendments to provisions that I consider to be appropriate, accounting for the relief sought by the submitters and the assessment within the officer's report. My evidence provides the reasoning for these amendments, however, in summary. Firstly, in terms of JIS policy P4, I consider that's generally appropriate in both its scope and intent, but that it requires amendment to provide greater clarity and certainty. Specifically, I think the term functional need should be underlined so that it adopts the corresponding definition in the district plan and in the national planning standards and avoids debate as to what that term might otherwise mean. I also think the policy should apply to both commercial activities that do not demonstrate a functional need, or rather than and, those activities that adversely affect the viability and function of other centres, and that's to ensure that either of these matters engage the policy. And finally, accounting for discount brands, I consider the policy should refer to activities that result in significant adverse effects on viability and function of other listed zones, rather than unacceptable effects which might undermine those zones. I've commented on that in other hearings around the use of wording that might be open to interpretation or uncertainty. Paragraph 10.2 of my summary, also consider that non-notification clauses are appropriate for the following rule requirements, where third-party involvement, in my view, is unlikely to assist in the determination of consent applications. Those rules relate to servicing, height, road boundary setbacks, and landscaping treatment for road boundaries. And finally, in terms of my summary, I consider the submitter's requested relief for a 20-metre building height in Rec 2 is more appropriate than the 15-metre height limit that's proposed by the officer, accounting for the costs, benefits and relative efficiencies of each option. And in terms of its effectiveness and potential effects, I consider a 20-metre limit as appropriate, accounting for the receiving environment and the distance from any sensitive sites or land uses, in the absence of any evidence that a 20-metre height limit will obviously affect important infrastructure. Probably at that point too, I'd just add, and it's not in my evidence, but I was mindful of discussing it and questioning if the opportunity arose, but it's probably timely to raise it. Since submitting that evidence and just dealing with other applications in Christchurch City, I thought it'd be useful to make the panel aware that in terms of the suggestion around non-notification requirements for height and a greater height limit, the Christchurch City Council's industrial general and industrial heavy zones have a height limit of 20 metres that applies within proximity to residential and rural zones, and beyond that there is no height limit. So I just think it's useful in terms of a comparable or adjacent district where you've got similar industrial activities and choosing where to locate. Those rules have probably been in place for perhaps 4 or 5 years now, where activities that are distant or buildings that are distant from those more sensitive zones, they can establish to whatever height they choose. So that concludes my summary. Happy to answer any questions that you might have.
Thank you. That's great. Thank you. I'll just ask if Commissioner Solomon has any questions first.
No, I don't have any questions. Thank you.
Cool.
I was going to ask a question about the height, but you've given more context to that, so thank you.
Okay, Andrew.
Thanks, Mr. Chairman. Thank you for your evidence, Mr. Phillips. So I'm just interested in the rationale for including large format retail within the policy that you've proposed to be amended. So paragraph 14 of your evidence, so policy 4, paragraph 14 and 12, 13, 14, you talk about adding large format retail into that policy. And I'm wondering if you've read the evidence of Ms. Panther Knight and her views on that change. And I guess I'm just keen to find a little bit more around what is the issue that what is the issue that I guess, commercial activities that might undermine, how would they undermine large format retail zone? It's not a centre as such in the hierarchy. What is the issue with protecting, and why would we need to do so for a large format retail zone?
Sure. Okay. So firstly, I haven't read Ms. Penther-Knight's evidence on that matter. I mean, that was a additional wording that I think the office has supported. I haven't gone into that into any length. From my understanding is that the large format retail zone does form part of the commercial and mixed use zones in the plan and part of that hierarchy. It provides for a range of retail activities that wouldn't otherwise be provided in industrial zones, so commercial activities. I think there's a recommendation in the LFR zone chapter from offices to include things like supermarkets, obviously make provision for large format retail, and then trade and similar type retail activity. So to the extent that I guess that zone is intended to specifically cater for those activities, that wording and that policy, in my view, would provide some protection or scope to consider the appropriateness of those types of activities where they might seek to establish en masse in an industrial zone where that might not be appropriate. An example might be, a large scale, I guess, pseudo large format zone looking to establish over a large area of industrial land, and whether that's appropriate in terms of the intended viability and function of the large format retail zone. And obviously my suggestion is that there's also consideration actually about functional need to establish within that location. So I think breaking all that down, I think the large format retail zone, in my view, does form part of that hierarchy. It's a zone with a specific purpose that can be distinguished from both the town centre zones and the local centre zones and the industrial zones, and it warrants consideration in that light.
So thank you. So maybe I'll just help you out. I'll just quote from here, paragraph, just given that you haven't read it.
Yep.
So paragraph 26, she says the policy is intended to and should be directed at focusing commercial activity in centres and protecting their vitality, viability, and function. The large format retail zone, whilst now enabling the supermarkets, ought not to be elevated in a hierarchy above the general industrial zone in this regard. I mean, I'm conscious that you did give me that answer before, but I'm also conscious that you didn't have that statement in front of you.
Mm-hmm.
And I guess what you're telling me is you think that the large format retail zone is within a centre's part of the centre's hierarchy and deserves protection, or its vitality, viability, and function. Is that what you're telling us?
Well, I think, in fairness, I'd say I'm not 100% clear without having considered it whether it is or isn't within that hierarchy. But I think regardless, I think even if it's not, and the centres hierarchy is specific to the town centres and local centre zones, and the large format retail zone is something else, I think my answer would stand in that the large format retail zone clearly serves a purpose. It's intentional. It's distinct from the industrial zone, and its intended function could be compromised by commercial activities that seek to establish in the general industrial zone, and so it remains a relevant policy test or consideration, in my view, in terms of maintaining that intended role.
So why would the community be concerned around viability of a large format retail zone if it was simply large format and didn't have council facilities or infrastructure or community service activities in it? It was just simply a shopping centre.
Well, I think if the large format retail zone is defined as a thing in the district plan on the basis that it serves a purpose of providing for large format needs, then, and again, this is possibly a question better directed to an economist, by allowing that activity to kind of bleed out into non-specific locations and spread it, for example, through industrial zones, is that a good outcome in terms of urban form and shared parking facilities and transportation and all of those other things, in terms of why you actually have centres and zones and consolidate activity in a single area? And again, I think there's two parts to it. There's viability and function. So even if viability weren't as important a test for large format zones, the function of that zone in terms of specifically catering for that type of activity may be important.
Okay.
And again, bear in mind, my recommendation is that wording refer to significant adverse effects rather than unacceptable and undermine. I think that wording would still, that's a pretty high bar for activities to meet. So I think you'd have to, for that limb of that policy to be engaged, you'd probably have to have something of substance. And again, the example I gave before would be, large area of general industrial zone land that could be, put forth as with a proposal for a whole load of large format retail and effectively become a quasi large format centre or zone in its own right.
Sure. So you kind of segue quite nicely into my next question. So just looking at your paragraph 16C, accounting for discount brands, the policy refer to activities that result in significant adverse effects on the viability and function. This point is consistent with, as elaborated on, my evidence and that of Mr. Gregory Hurst for the submitters for topic 23. So, I wasn't in that hearing. Can you just please elaborate for me a little bit more around the justification for that?
Yeah, so in simple terms, the term significant is sort of tried and tested in my view. It's a known test. It's the courts have had to grapple with it in various cases, and discount brands being sort of the most notable one of those. To distinguish between normal trade competition effects and something, of a greater magnitude that warrants intervention. It's not to say that unacceptable or undermine might be necessarily wrong. And again, I think everyone's on the same page around intent. I think again, it's just from a clarity point of view. If you introduce those other terms, if they're not defined and they're open to interpretation, how I interpret unacceptable or undermine might be different to how you or anyone else referring to the plan does. So my preference is to either have a defined term or a term that's commonly used.
No, that's very helpful. Thank you. And I just have one final question. If I can just find where it is. So 18.3, I think you're talking about road boundary setbacks for buildings and landscaping strips and non-notification clauses. And I think you've said in there, I consider a non-notification clause to be appropriate on the basis that such activities are unlikely to affect other persons directly, given the nature of buildings and activities within the zone. And I'm just wondering, could there be a situation where a neighbour was relying on, bulk and location provisions for a building to be set back in order to determine their own development? And if they weren't able to comment on it, is that do you think that's reasonable? So if the setback's not limited to notified, but they're relying on the application of the rule?
Yeah, I don't think that's a significant enough justification to necessarily change that view that non-notification is appropriate. I think if you, people interpreting what they might be able to do on their own site and accounting for what would be occurring on other sites, like part of their evaluation, aside from looking at what's permitted, might be to say, well, there is the possibility that someone could apply for a consent and it may be granted without my involvement. So I think they've got the ability to factor that into their decision making about how they use their site and to what extent they sort of rely on those setbacks on adjacent property with their own site. Also, they benefit, I guess, from having a process that's just between them and council. And thirdly, I think where I've supported the use of non-notification clauses throughout a number of chapters on this plan is that just because it's a non-notified process, it's not a free pass. You've still got to go through a resource consent. The relevant assessment criteria are still open to consideration, and council could look at something and say, look, this is not appropriate, we're going to refuse consent, or we're going to condition the activity. So I think that safeguard's still there. I think I come back to the key point here is that the general industrial zone is not a zone where there's any great importance placed on amenity within the zone. And so be that in relation to the height of buildings or the setback from road boundaries, I think it's actually about allowing for relatively unencumbered and free and efficient use of the land resource within those zones, rather than necessarily constraining that where there's not a good reason to do so. And then again, I'm not actually suggesting a change to that standard, just that if a resource consent's required, it's a process between applicants and council.
Thank you. And are there examples of this particular rule in other plans that you could point us to where it's not?
Sure. Yep. So again, Christchurch City, the industrial general zone, minimum setbacks from road boundaries, that's non-notified and shall not be limited notified. That rule sort of coincides also with setbacks from rail corridor boundaries and says it shall only be limited notified to Kiwi Rail. So they've obviously identified there's a specific party who might have an interest there, but in general terms, the industrial general zone and Christchurch City has has no requirement for notification. The industrial heavy zone, I'll just check that now. My understanding is that there's actually no road boundary setback at all, so you don't even need a road boundary setback, but I'll confirm that for you if you can give me 2 seconds. Sorry, I stand corrected. The setback is actually 1.5 metres from road boundaries, unless you're in a fronting an arterial road or opposite a residential zone where it pushes out to 3 metres. But again, that's got a direction for non-notification, no public notification and no limited notification.
Okay, no, thank you. That's helpful to have that sort of context. Thank you for that. No further questions.
Thank you for that. I didn't completely hear the questioning on 18.3 because I was preparing my next question, but in case it wasn't covered, is that the rule? Your paragraph 18.3 refers to rules where the officer is recommending the setback be reduced from 10 metres to 3 metres. Is that
correct? Yes. So I support the amendment to the rule, but the focus there is on the appropriateness or not of having a non-notification clause to go with it, and I consider that it would be appropriate for the reasons I've stated to also have a non-notification direction, so that it's a matter just between applicants for resource consent and the council.
Yep. So you maintain that position even with a 3 metre setback.
Correct.
All right, understand that. Thank you. I have some other questions. Next one was 16.16a, I think it is. Yeah, just on the functional need, you've asked that it be linked to, or hyperlinked, I guess, to a definition in the plan. Without me going and looking at that, is there anything you can summarise? What does functional need mean in terms of the plan, other than in common English terms?
I'll bring it up and then I can tell you. So it's a functional need is defined in the plan. It means the need for a proposal or activity to traverse, locate, or operate in a particular environment because the activity can only occur in that environment. So they're the words for, and that would be the test, I guess, as to whether something has a functional need. One of the reasons for raising this issue, and again, without harping on about the Christchurch City Council down the road, but from experience, they've had tests referring to things like operational and strategic need in their policies, and it's become a effectively a gateway test for a lot of activities. It's been exceptionally uncertain for users of the plan, both council administering it, applicants and their advisors in terms of trying to interpret it. There's actually been a lot of debate about what need means in terms of it being entailing sort of necessity rather than preference. But I think, again, I'm probably jaundiced by my experience and with a relatively new plan in Christchurch City Council, where I think the intent has been everyone's been on the same page in terms of the intent of these provisions at the time they're drafted and determined, but then the words on the page of what counts when it comes to an application. So I think I'm all for certainty where it can be provided, and so I think if you've got a defined term rather than leaving it to myself or someone else to try and put their spin on what functional need might mean or might not mean, I think that's helpful.
Understand that point. Just going back to what you said, that I tried to absorb something about can only locate in that zone. Is that
correct? It means the need for a proposal or activity to traverse, locate, or operate in a particular environment because the activity can only occur in that environment.
Okay, that's quite a high bar, I would have thought. Would you agree with that? It's a fairly
correct.
Yeah. Okay.
Yep.
All right. Thank you. Now, I had another question about your paragraph 14. There's a lot of reference to policy. I think that one's P4, isn't it?
Correct.
We asked the previous submitter, Cape Panther Knight, about the word avoid. Do you have any view on the word avoid in that policy, and I think also in P3? Does that, in your view, set up a non-complying activity status necessarily, or do you have a different view on that?
I would have thought avoid would naturally translate into a non-complying activity status. I think I'd caution, and again, I've probably said it in other hearings too. I mean, if you use the term avoid, make sure that's what you mean, because it can effectively be create a prohibited activity status for things by way of policy. So if you're an activity that, we just talked about the term functional need and that having a very specific meaning. If you don't happen to fit within the listed range of activities and you engage that policy and you don't have a functional need, then chances are you're not going to get a resource consent. So
So thank you for that. So with the words we're focused on the other words in that policy that do not demonstrate a functional need, et cetera, et cetera. So it has an avoid word, but it also has some qualifiers. And would it be your view as a planner that enables a merits-based assessment, even with the word avoid? Like, for instance, if that leads to a non-complying activity status, would someone be able to have their application assessed on its merits because of the other qualifiers in there, or would it be a sort of a knockout blow that's hard to pass?
So I think, well, yes, I mean, non-compliant activity, yes, you get the chance to advance your merits. I think then that comes back to, the two limbs effects, so assuming you can satisfy the limb around effects, and then the focus becomes how you sit in terms of that policy. So avoid means avoid. We all know what that means. It then comes down to, I guess, a merits or evidential-based assessment as to whether you can demonstrate a functional need to locate within the zone, and, or in my view, not have the level of effects on sort of viability and function of those other centres. And if you can't do that, then I think that would be a fatal blow. I think if you can do so, then you should back to overall judgment.
Okay. I think that's helpful. Thank you for that. Next question was 18.1. This is when you're talking about non-notification clauses, and you've talked here about the reticulated sewer being provided, and you think it's not non-complying activity status. Hold on. I do not agree with the officer that NC status is relevant to the issue of notification. I'm just trying to think, would there be your general proposition is that non-notification clauses should be invoked where it's really only the local environment we're considering, the effects on neighbours, that sort of thing. There's no need to have it fully notified. But with something like the sewer connection, is that more of a policy precedent sort of issue that should perhaps be able to be publicly notified? Any comment on that?
Well, again, I think the key way I view notification is that it's got to be of benefit to the quality of the decision making in terms of bringing information to bear that's relevant to that decision making, and that issue of whether or not you have sewer, whether there's precedent effects or policy effects. Again, I think that's a matter that the council is suitably equipped to determine in its own right. I mean, I think the way that rule has come about is to sort of signal the expectation that sites will have reticulated sewer before they commence development in simple terms. So if you don't have sewer, there's a problem. But again, I think that's a problem that either applicants can make the case as to why that problem's not insurmountable and consent should be granted, and council can consider that, and it's not going to be assisted by having other parties involved.
So it's not a precedent matter. You don't think it's a matter that leads to precedent? Well,
I think even if it was, I'm not sure that I'm not of the view that again is assisted. The determination of that issue is assisted by having submissions from other persons. I mean, council could consider and say, look, there is a severe precedent risk here that if we grant consent, we're going to have a bunch of activities fronting up wanting to establish without reticulated sewer in place, and that runs counter to provisions in the plan, or would have adverse effects that are unacceptable. Therefore, consent should be refused. I think that's a position that they could reasonably establish, and a decision maker could reasonably determine without assistance from submitters.
Thank you for that. Final question, just in relation to the height issue about increasing the height from 15 to 20 metres in the Jones, Hoskins, Madison's Road area. Incidentally, we will be doing a site visit shortly, and we'll go past the area and have a quick look. But as decision makers on the panel, I'm just questioning whether we have enough evidence to, from you as a submitter, to make a decision to increase the height limit by potentially 5 metres, which is almost 2 stories. Have you included evidence as part of the original submission on what the effects of that might be for us to consider? We are obliged to apply Section 32AA to any changes to the notified plan, significant changes. Any comment on that, or is there anything you can point us to that would help us make
per se in the submission that I'm aware of? I mean, I think from memory, the submission pointed to sort of probably the practical factors and distance from sensitive receiving environments. I think to what may be of assistance were the comments that I made earlier, drawing attention to, again, Christchurch City Council's plan, which I guess is tried and tested, and it's gone through that Section 32 evaluation, and it's been in place where there's a similar approach, I guess, to what's proposed, which is that a greater height limit is provided for where it's not proximate to sensitive receiving zones in terms of rural residential zones. I think when I opened and I referred to that, I mentioned wasn't probably particularly clear about what that standard is, but having it up in front of me, the standard is that the maximum height of any building within 20 metres of a residential or rural zone should be 15 metres. So they do limit it to 15 metres within 20 metres of rural residential zones. Beyond that, there is no height limit. So that,
If I understand correctly, that the 15 metres is in the operative plan, and the officer's response is that there's not proposed to be any change to that. So that is the case, is it? Status quo?
That's my understanding of what's proposed. I think the point I'm making there, I think, is the an alternative form of relief to what I've suggested of just having a 20-metre height limit for that specified area could be something that's actually more akin to what the Christchurch City example is, where you have either a higher height limit of 20 metres or otherwise, or no height limit for argument's sake, where it's a specified distance from those rural residential zones, which would probably have the same effect, because I think when you do your site visit, you'll see that that particular area of iPort and that part of the general industrial zone is distant from rural and residential zones, so it sort of achieves the same outcome.
Yep. And I think I read your evidence to say that there's been no further submissions opposing your submission from the adjoining landowner. Is that correct? Correct,
and that's particularly relevant in terms of the port. So I think one of the officer's concerns was about potential impacts on strategic infrastructure. There wasn't any sort of elaboration on which strategic infrastructure might be of concern, but I think to the extent that there's any concern about impacts on the port zone, well, I think that may have mentioned that having a higher height limit anyway. The port zone has a 20-metre height limit. I've noted that in paragraph 23, and LPC, who's responsible for that port zone, haven't submitted or provided further submissions opposing the relief that's been sought.
Thank you very much for those answers. I've got no further questions, so thank you.
Thank you.
So, thank you very much. Okay, we'll move on to the next submitter, if they happen to be there. That's Littleton Port Company, Midland Port. Mr. Bonus, yes. Hello, Mr. Welcome to the hearing. And Mr. Bonus, are you by yourself, or do you have Ms. Hill with you as well?
I understood that Ms. Hill was going to be available, and it looks like she's connecting just now, but not this year.
Okay, I suppose the protocol is I hand over to you, Ms. Hill. Welcome to the hearing. You have Mr. Bonus with you. We're in your hands as to how you wish to present.
Thank you. Yes, I'll do a really brief introduction and then I'll hand over to Mr. Bonus. We're here for LPC and have one fairly discrete matter to discuss, which is the rules related to residential activity in the general industrial zone. There's a portion of the general industrial zone in Rolleston which is covered by the port noise control overlay. Just briefly before I hand over to Mr. Bonus, I wanted to flag one thing which came up in our preparation for this hearing, which is just a point of interpretation that I suppose LPC has maybe taken for granted the whole way through, that we wanted to flag in terms of our thinking, which is that LPC has read the rules as that's rules R2 and R3 as essentially having the effect that residential activity is limited to activities in an existing residential unit, and the only residential units that may be established in the general industrial zone are those for custodial sort of supervision of the site itself. We note there is now this new activity category of community corrections facilities, and LPC just wanted to flag that it has assumed none of those facilities would involve housing, or that if they did, the residential activity rules would be triggered. We note the definition of community corrections facility is not sort of particularly clear one way or the other on that front, but we've also read the evidence of Mr. Dale for the Department of Corrections, which appears to describe activities like yard-based job training workshops. So LPC doesn't understand this as a major problem. We just wanted to let the panel know that that's how LPC has been approaching the rule interpretation overall for this chapter, and just reiterate that generally the position is, as was discussed in the noise hearing, LPC is really seeking to avoid or heavily limit the ability to establish residential activity in the noise control overlay.
So just on that, thank you very much. We'll ask the reporting officer to comment on that either now or in the right of reply. But we have a tabled letter from Mr. Dale, and we will be considering that, and we will ask that question of him about what corrections facilities actually entail, whether it does include a residential component. We understand it doesn't, but we'll seek to have that clarified. We'll keep that in mind when we consider your submissions as well. So thank you very much.
Thank you, sir. I'll hand over to Mr. Bonis now.
All right. Okay. Thank you, Mr. Bonis. All right. You presented a brief summary statement too, I believe, in the last couple of days. So if you wish to just perhaps read that and highlight any other key points you wish to make, that'd be great. Thank you.
Thank you, sir, and thank you, panel. As identified by Ms. Hill, it's a very, very narrow matter in terms of my evidence for LPC. In all other respects, the evidence provides support for the provisions in terms of how they've been amended by the 42A reporting officer. In terms of community facilities, I also agree with the point of interpretation provided by Ms. Hill. My understanding of the interplay between R2 and R3 is that everything really hangs off the definition of R2 and residential unit, which would also tie into community facilities if they proposed such, and would be limited accordingly. So the premise or the basis, I guess, of the suggestion for the recommendation to R2 is really about refinement to an restricted discretionary activity status within the 45 dBA port noise control overlay. The refinement I've recommended, and I've attached that to the bottom of the summary, is a consequential change which, in my view, provides more certainty and precision to the rules and is the more efficient. The basis for that requested change is set out in paragraphs 24 to 39 of my evidence in chief. And specifically, I've identified for the panel at 27.1 and 33.A a specific concern that I have with the way that custodial on-site security purposes is defined within the plan is that it isn't defined. There really isn't an interpretation behind it. It's largely untethered from what would be activities within the site. And the basis of my evidence in chief around this particular matter funnels back to the ongoing issues that LPC and myself as a planning officer for LPC have had with sort of live-work units that have established on Desi Place, adjacent to City Depot, and the consequential changes in amenity expectations that have gone with those. And my evidence identifies that through consenting processes, there have been restrictions provided to LPC accordingly. And in terms of the policies and objectives of the plan around reverse sensitivity and the need for efficient and effective operations for important infrastructure. Obviously, that's something that, in my view, doesn't fit within the nexus of the plan. So the purpose of the amendment, as I've sought it, and also within the scope of the LPC submission, the primary preference for me was actually to try and tether down custodial units to being ancillary to permitted activities within the zone itself. But the LPC submission was really just targeted towards the 45 dBA contour. So accordingly, I've recommended a restricted discretionary status, and it effectively just amends the status for custodial units within the 45 dBA noise control overlay. And that allows for a number of things. It identifies, it provides the ability for those consents to be declined, whereas currently under a controlled activity status they can't be. It also allows a bit more rigorous testing in terms of the relationship of the residential occupiers and the activity itself to make sure that there is actually an appropriate link to a permitted activity. And also it provides further scope to look at the design and location of the residential unit, including the outdoor living space. So that's essentially the basis of my summary and recommendation to the panel. Any questions?
Thank you for that. We'll just see if we have any questions. First of all, Commissioner Solomon.
Yes, I just have a couple. At your paragraph 26 in your evidence in chief, where you've talked about custodial units located on Desi Place and Nuttall Drive, were they not linked to a primary industrial uses of the City Depot?
No, so they're outside the City Depot. They're on the adjoining, what was the Business 4 industrial land. And the operative plan at that time provided for essentially what were called live-work units. So the rule was equally untethered to being associated with or ancillary to a permitted activity. It was essentially referred to for being there for security or managerial purposes, from memory, going back to the rule. And what that essentially meant is down Desi Place, and it's certainly worthwhile going and having a look. A number of two-storey terraces were provided with quite a large warehouse space below, where you'd get some semblance of an industrial activity, but the larger occupied dwelling above would essentially have hold a residential family. And they ticked the box in terms of being a live-work unit, but clearly they were there with an expectation around residential occupation rather than a primary sort of industrial activity.
Okay, and I take your point about on-site security needing to be more defined or more precise, and for it to be tied to a primary permitted activity. You provide a clear example of that in your paragraph 26. So I just want to thank you for that example. I understood the point better that you were trying to make.
Thank you.
No questions from me. Thank you.
Andrew.
Thank you, Mr. Chairman. Yes, just a couple of questions. Thank you for your evidence, Mr. Bonis. My first question is really just seeing if you wished to comment on this. It's a matter which Mr. Phillips raised in his evidence. And I'm not sure if you've referred to it or you just saw what his evidence before and questions around him. But he does cover in his paragraph 23, he refers to the port zone and LPC and the matter of height limits. And you may not have a comment at all on that, but do you have a view on his evidence in relation to height limits in the general industrial zone, given that he's referenced the port zone and LPC submission and also the matter of infrastructure?
No, I haven't read his evidence, but I did listen to his response to the questions. My understanding from his answer was that LPC didn't have a submission or a further submission on that particular issue. Furthermore, we do see some degree of similarity between the environmental expectations between the port and the general industrial zone in terms of built form. LPC has secured a reasonably generous height, which is anticipated and expected given the sort of container stacking that's necessary there. So I don't see any issue with where Mr. Phillips has gone based on my understanding of his response to the panel questions.
Thank you. I appreciate you giving your response because, I mean, yeah, that was just whether you had an observation or not. I appreciate that. Thank you. So in your paragraph 16.3, and you refer to the General Industrial Zone Rule 8 retail activities, and you support that as notified. So just for clarity, you support the rule, the whole rule, and do you support the fact that it non-compliance defaults to non-complying activity status as opposed to some other status? Is that correct?
Yes, I do. I think it's appropriate given the policy framework, specifically P3 and P4, which turn its face against those commercial activities that don't have a natural place or natural activities and effects within the general industrial zone. And I think I've identified in this evidence, certainly for the nature of the operations for the port, which is very noisy, has a lot of height associated with it and goes 24/7. There is an aversion to activities adjoining or within proximity that either attract large number of traffic vehicles, because obviously the port's distributional component is a key aspect in terms of its functional requirements, but also any change in expectations around public-facing areas, which you'd automatically get with sort of retail and commercial activities, which could result in reverse sensitivity issues for the port. So no, I very much am in favour of a non-compliant activity status.
Thank you. And so, and if that was, do you have a view on the appropriateness or otherwise of supermarkets? Should they be discretionary or non-complying? And appreciate, do you wish to comment on that?
To be honest, that's not an answer that I could give you in an appropriate sense. There are a number of variables that would need to go into a consideration around the status for supermarkets. Primarily, though, in terms of the position that I have based on the Selwyn district plan provisions, the capacity for commercial activities within commercial centres, a large format retail zone. It takes a very segmented view in terms of where these activities should and shouldn't be. And in this particular instance around the general industrial zone and its relationship with the port zone, I'm very much of the view that supermarkets should be non-compliant.
Okay, thank you. Appreciate your views on that. And my final question, and I'm just interested. So it relates to your paragraph 21 and 22, and it's in relation to the recommended changes to General Industrial Zone Rule 2 residential unit. And I think, remind me, did LPC make a submission on noise R5 in relation to this matter? Because I don't recall. I understand that the activities are permitted within the 45 dB overlay. Acoustic attenuation is provided, and I wasn't sure whether LPC lodged a submission on that rule, noise R5. I didn't see it.
Yes.
I didn't recall it coming up. You did?
No, we certainly did, and we turned up in support of what those provisions were. I've been very careful in my evidence to identify that the acoustic expert evidence provided for LPC for the noise proposal from Mr. Hegley identified that the 45 dB, this is at my paragraph 34, provided evidence that the 45 dBA was the appropriate boundary in terms of requiring mitigation, so acoustic insulation and also ventilation requirements that would go for any habitable dwelling or noise sensitive activity within the 45. The purpose, and I've carefully tried to spell it out, is within the general industrial zone, within that contour, it isn't really just around ensuring that you've got appropriate levels of amenity in habitable rooms for sleep and so forth. In terms of what Mr. Hegley was saying, it's broader and wider than that. It really goes into the design of those spaces. Is there a actual security purpose for that activity being there in the first place? What is there a relationship and a link between the amenity that residential unit would have and the nature of the industrial activity or permitted activity actually on the site itself? And furthermore, greater control around outdoor living space and outdoor living amenity. For example, whilst there's a 70 square metre limitation in GFA in terms of the residential unit, there's no restrictions at all in terms of what the associated outdoor living area would be, decking and so forth. So what I've tried to do, and the noise 5 rule I think reverts to non-complying in terms of acoustic attenuation, is that the status of this is restricted discretionary, and it really is around looking at those variables around livability and why they're there, rather than specifically going to will they get habitable levels of acoustic noise that they can sleep at night, because that's already done through the noise proposal. So this is another limb, and I've been quite clear with that in terms of my paragraph 34.
Okay, thank you. No further questions.
Nicole, you had a question.
Yeah, thank you. I've just had a question with your events that you've been speaking about. So you're, with being a port, are in a special port zone, and you made reference to like you don't want to be limited in with your stacking of your containers. What height can you stack containers to now?
The appropriate functional person who could talk about it is listening in, but I don't think he has a link. From memory, it's about 25 metres, but I would just need to quickly confirm that.
If you could clarify, that would be good. Thank you.
I'll do that now. Thank you.
While Mr. Bonis does that quickly, I might jump in and remind the panel that LBC has also got a resource consent for Midland Port. So perhaps if Mr. Bonis could, if we can't get it quickly, we can quickly let the hearings coordinator know whether there's
Thank you. No, thank you.
And just while you're doing that, Mr. Bonis, I'll just state that you were asked a question about supermarkets and whether they should be, in your view, as a provisional plan of discretion or non-complying. You gave an answer. We may not be able to place much weight on that answer. we'll have to consider whether, certainly not part of the submission that was lodged by your client. But thank you for providing that advice. Just for the record, I'll just signal here that the panel may not put much weight on that answer in terms of the protocols, but thank you anyway.
No, look, and I agree, and I caveated that answer with there are a number of variables that go into a decision made by the panel in that regard, and I don't have access to or visibility to what all those variables are.
Are you ready to answer that other question?
Uh, 25 metres is my understanding, and that pretty much provides for container stacking up to, I think it was 7, but we'll confirm that through the panel. The only exception was the 150 metre area fronting Jones Road, where the stormwater swale and basins are, and there's a lower height limit that's provided for that. But Ms Hill was also correct that there's a specific resource consent, and we amended that through the COVID lockdown last year to provide us up to a similar level of 25 metres. But I'll provide a quick note to Ms Hill to provide to the panel, just linking those two things together so that they've got that formally in front of them.
Thank you. Is that all? Yep. I just had one further question, Mr. Bonus, just in relation to the relief. Thank you for helpfully spelling out in paragraph 21 what the submitter asked for there. So controlled activity, if it's not located within the noise control overlay, it would trip to non-complying. And in your final table, you've suggested another way of doing it, which would be to make the first two parts of that rule, A and B, non-complying, and then introduce a restricted discretionary component if C is not achieved. Sorry, have I got that right? So you're basically making it more flexible for A and B, but not C. Is that right? Is that what intended?
I see. That's a valid point. I'll look at that further. The intent was obviously to provide a consenting status where within the Port 45 DBA contour they could be declined, which can still happen under RD21C. If, for example, it was within the 45 dBA contour and it wasn't used for custodial or site, if it was and it wasn't used for custodial or it was over 70 square metres, it could also be declined. So no, sir, sorry, upon reflection, that's absolutely fine. The criteria in A and B appropriately do fall into a non-complying activity status across the zone as a whole. C just simply provides an additional layer so that the port is able to get involved for restricted discretionary consent is available for anything within the Port 45 dBA LEQ contour. So no, sir, that's appropriately structured.
That is correct, isn't it? Yes. So
yes, sir.
In terms of scope, it's slightly watering down what you asked for in relief. So I believe that is within scope.
I agree, sir, and that was done deliberately because a non-complying activity status seemed to be a bit perhaps less efficient and effective in terms of what may otherwise be appropriate.
And if we were to accept that it should be non-complying in those circumstances, what would be the policy framework we'd be hanging that off? Is that under the noise chapter or is it within this chapter, do you think?
It would be under the noise chapter and also the energy and infrastructure chapter, predominantly the latter, sir. The specific policy in there in terms of reverse sensitivity and avoiding that in terms of the efficient and effective operation of important infrastructure.
I wasn't at either of those hearings, but I believe some of my panel members were. Commissioner Willis certainly was. All right, no, so thanks for that answer. That's useful. I think that's it, actually. Yeah, I've got no further questions. So, Ms. Hill, have you got anything further to say, or we can leave it at that?
No, nothing further to say. Thank you.
We will seek some clarification from corrections on the residential component of their facilities, and and that'll form part of our deliberations. So thank you very much for your participation. Thank you.
Thank you, sir. Thank you all.
Okay, we'll take an adjournment now and reconvene at, well, that's the adjournment for this hearing. We've got another hearing starting at 2 o'clock. Same panel. Anyway, thank you very much.
Thank you.